Welcome to our Curious Amalgam, the weekly podcast brought to you by the Antitrust Law section of the American Bar Association. Our Curious Amalgam explores the fascinating and increasingly overlapping world of competition, consumer protection, data protection, and privacy law. Each week, we bring you leading global experts on the most compelling issues of the day. Enjoy the show.
Hello, and welcome to Our Curious Amalgam, the podcast from the American Bar Association Antitrust Law section. My name is Christina and today's topic is The Trouble with Treble, examining the effects of mandatory treble damages. The Sherman Act, which prohibits agreements in restraint of trade and acts of monopolization, contemplates treble or triple damages. In this episode of Our Curious Amalgam, we'll explore the origins of treble damages, what it has meant for the practice of antitrust, and whether it's due for an overhaul. Joining me today is my co-host, Matt Michaloski. Hey, Matt.
Hello, glad to be here and glad to be learning from our guest.
And who is our guest today?
Our guest today is Henry Hauser. Henry is counsel at Perkins Coie and an adjunct professor at the University of Colorado Law School. Previously, he was a trial attorney in the United States Department of Justice Antitrust Division. He worked in the FTC's Technology Enforcement Division and clerked for Judge Gonzales Rogers in the United States District Court for the Northern District of California. In the fall of 2022, Henry co-authored a headnote in the Minnesota Law Review examining the consequences of mandatory treble damages in U.S. antitrust law. In that paper, he surveyed the arguments that have been raised both for and against having mandatory treble damages and brought behavioral economics to bear on that question. And he is with us today to discuss the same topic. Welcome, Henry.
Christina, Matt, thanks so much for having me. Pleasure to be here.
So, Henry, maybe let's start with a very easy question. What are treble damages?
Contrary to what some might think, treble damages are not, in fact, an all-women a cappella group. It's actually much more straightforward than that. Treble damages are triple damages. So at the end of a trial, you have a verdict, and whatever the proven damages are, those get magnified under our antitrust laws by a factor of 3. Whatever the measure, whether it's lost profits, gain, overcharge, that end number gets multiplied by 3 at the end of the day.
And Henry, can you tell us about the origins of the treble damages remedy?
Sure, Matt. Section 4 of the Clayton Act requires courts, not discretionary, requires courts to award threefold the damages sustained. But treble damages go back further than just the Clayton Act. They were already a feature of U.S. antitrust law for about 25 years, dating back to the original passage of the Sherman Act as well. But it goes back quite a bit further than that. We have to go back actually 400 years this year to 1623 to the British Statute of Monopolies. That statute entitled plaintiffs to 3 times the damages sustained when hindered, grieved, disturbed, or disquieted in his goods or chattels, and any way attached, distrained, or taken by occasion or pretext of any monopoly. So these have been a feature of Anglo-American law for about 400 years, U.S. law for well over a century. How they actually came into U.S. law is pretty interesting, and we actually don't know a whole lot about it. We know that the original Sherman Act proposal allowed for the recovery of the amount of actual enhancement in price, which looks more like single damages. It was Senator Sherman that argued that damages should be commensurate with the difficulty of maintaining a private suit, and he proposed double damages. It was only in a subsequent amendment to that through the Senate version as well that treble or triple damages were introduced into the conversation, and as we know, that ultimately is the version that was passed into law.
So the idea seems to have been that the recovery has to be greater than 100% in some multiple in order to incentivize enforcement actions. Is that correct?
That was definitely part of the idea, to incentivize enforcement actions, and even the initial justification and rationale does contemplate having a really strong deterrence, having some sort of a private supplement to whatever the government was going to do in this field. And don't forget, when the Sherman Act is passed, there's no Department of Justice Antitrust Division. There aren't state attorneys generals prosecuting antitrust conduct. There's no Federal Trade Commission. That doesn't exist and won't for several decades. So this was part of the competition puzzle that the framers of the Sherman Act were trying to solve here.
Are there examples of treble damages remedies in other laws?
There are examples of treble damages remedies. What there are not examples of are treble damage remedies in a economic statute that governs marketplace behavior. And what we also don't have is a blanket requirement to allow treble damages in all cases. That's again, it's a unique factor of our antitrust laws is that there's no exit ramp. If you have a violation, that violation is subject to treble damages. A good comparison is RICO. RICO is not strictly a statute governing marketplace behavior. It governs criminal concerted action conduct, which in some ways is a better analogy to cartel conduct in the antitrust side than monopolization conduct. RICO allows for treble damages in a number of cases, but it doesn't require them in any case. So there's still some daylight between even the cartel aspect of our Sherman Act and RICO in terms of that strict requirement in all instances, no exceptions, triple the damages.
Thanks, Henry. So even though we may not have a whole lot of insight into what the congressmen who originally passed the Sherman Act were thinking about the value of that remedy, what value do treble damages serve? What positive implications of that remedy have people identified?
That's a great question, and this is something that courts, commentators, government officials have all commented and analyzed. And the short answer is they do a lot of good. In fact, going to the original rationale, they certainly do incentivize private enforcement by allowing and requiring for triple the damages. That does change the cost benefit calculation of bringing and investing in an antitrust suit. We'll talk about the flip side of that in a moment, but this is a rationale that the Supreme Court has even specifically acknowledged in the American Society of Mechanical Engineers case. The court wrote that Congress created this remedy precisely for the purpose of encouraging private challenges to antitrust violations. They went on to say that these private suits provide a significant supplement to the limited resources available to the Department of Justice for enforcing antitrust laws and deterring violations. So in that way, it is a powerful financial incentive for the private enforcement of antitrust laws. Other commentators have noted that Congress wanted to give the private sector an incentive to function as a self-policing system, so it wouldn't just be left up to the DOJ and later the FTC. So that's the first rationale and first good thing and important thing that does come out of treble damages.
It was interesting that you mentioned earlier that when we thought about, or when treble damages were contemplated, there was no government enforcement. With the revisions of the Clayton Act, with the revisions of, I shouldn't say revisions, but with the adoption of the FTC Act, was there ever a discussion about the lessened need for private enforcement in view of DOJ and FTC jurisdiction?
It doesn't look like there was a ton of discussion over that. There was a very comprehensive retro study in the 1980s by Professor Garvey to the House of Representatives, the House Judiciary Committee, really analyzing the history of treble damages, which at that point was about just shy of 100 years old at that point. So that was a pretty comprehensive study. But let's not forget that's 1984. So we're already 70 years past the Clayton Act when these treble damages were imported from the original Sherman Act. And it doesn't look like there was a huge amount of discussion over the role of the private bar at that time, the increasing availability of class action lawsuits, which did not look the same and did not have the same general availability as they do today when the Sherman Act was passed in 1890 or when that treble damage provision was imported into the Clayton Act about 25 years after that.
Are there other arguments that have been raised in support of treble damages?
A few others that are also very important. In addition to incentivizing private enforcement, treble damages are also seen as a way to deter anti-competitive conduct. The threat of treble damages changes the cost-benefit analysis for companies as well, especially when it comes to clear-cut antitrust violations. This is something that the court in Mitsubishi Motors recognized as well, noting that this treble damages provision is a chief tool in the antitrust enforcement scheme, posing a crucial deterrent to potential violators. So as a result of treble damages, we might have fewer violations due to that deterrent effect and the threat and the risk of incurring such massive liability, triple liability to the actual damages that would be awarded in a different type of case, maybe a contract breach case or an employment case. And finally, there's an idea that treble damages, or at least some multiplier, is necessary to fully compensate victims. Antitrust cases take a long time. The time value of money factors into play here. And of course, a plaintiff might not be able to put in evidence and prove damages for all the losses that they have suffered. In the same vein, not every antitrust violation goes detected. So there's the concept that to achieve the right deterrence, the right compensation, we need some type of multiplier on damages. I think Professor Garvey noted this very well in his 1984 report to Congress. This is a vehicle for punishing the violator, deterring misconduct, and compensating the victim. Those are the three main pillars for why we have treble damages and why they have functioned in a lot of cases effectively up to this point.
Do we think, as you noted, the access to class actions sort of limits the strength of those arguments today? I know there's a lot of discussion about whether class action cert is too difficult as well. So that's another debate to be had on another episode. But I wonder how, the interplay between those two.
It's an important point because class actions looked very different in 1890 or in the 19-teens than they do today. So to the extent that allows more adequate compensation for victims, the fact that those class actions, the threat of those class actions might in fact create some deterrence in and of themselves and incentivize private enforcement by their own account. It's an important point, and I wonder if these elements of our legal system were in place when the Sherman or Clayton Act were passed, whether the debate would have been a little bit different in taking those into account. It's a good point.
It's probably a good segue to talking a little bit about why treble damages might be a bad idea. So what are the arguments against treble damages?
So they've been subject to criticism also from judges, even government officials, and the private bar. One is that these are an anomaly, and we've touched on this before. There's not another statute governing marketplace behavior that requires treble damages in all cases. You've got criminal statutes like RICO that in a lot of cases do require it, but that would be a more of an argument for why treble damages should apply to criminal antitrust conduct or collusive concerted action. The connection to Section 2 there, to monopolization, is a little less clear, and it seems like more of an outlier. The other thing to keep in mind is that other countries generally do not require or even allow for treble damages. Some countries calculate damages through different metrics like revenue or turnover, but in that sense, it does make us as a country, as a legal system, stick out a bit in terms of antitrust enforcement. But one note that I came across from Professor Weber that other countries are sometimes reluctant to enforce U.S. antitrust judgments on comedy grounds or commit to doing so because the feeling that treble damages in the U.S. are too punitive and it doesn't align well with their legal system. So it's an anomaly in our legal system, and it could also be creating some tension potentially with coordination and collaboration with other countries as well.
So one potential harm that's been raised by various sources and that you survey in your paper is the idea that if treble damages are hanging over an antitrust action, it may in fact create a sort of bias in favor of defendants insofar as it disproportionately raises the cost of a type 1 error by letting a finding of liability go through when such a massive, I suppose, remedy is going to be imposed. So can you talk about the consequences that creates?
This is something that interested me as a whatever below amateur behavioral economist is, maybe a hobbyist, you can say. So type 1 errors, a false positive, a false finding of a violation where in fact no violation has occurred. That's what we call type 1 error. So in a non-antitrust case, take a contract case, the magnitude of a type 1 error, so an incorrect ruling for the defendant, and a type 2 error, an incorrect ruling for the plaintiff, are symmetrical. Either the plaintiff suffered damages that they don't get to recover, or the defendant didn't do anything wrong and has to pay 1x damages on conduct that was actually pretty innocuous. If you have a close call in those cases where it's really hard to make the decision, the judge is on the fence, it's 50-50, it feels like both sides are on an equal playing field because the probability of getting it right and the magnitude of getting it wrong line up in a non-antitrust case. The damages are the same as the harm. But in an antitrust case, that might not be so true with the triple magnitude concept of a false finding of a violation. In that case, a judge is looking at this, maybe not consciously, but possibly unconsciously in the back of their minds, moving the needle a little bit. Is a false finding for the defendant means that plaintiff suffers harm that it doesn't get to recover, but an incorrect finding for the plaintiff means that the defendant has to pay triple those damages. So the error cost in some ways can be seen as magnified by a factor of 3. And if they're behaving like strictly rational actors, there is something in the back of their minds potentially telling them, well, let's be careful here. Wouldn't it be better to make an error that's only 1x bad versus an error that is 3x bad? And there's some reason to believe that could cause substantive rulings to differ in antitrust cases versus contract cases or employment cases. So the idea that substantive antitrust decisions might be different without treble damages. This is something that former government officials, former FTC chair William Kovacic has stated that requiring mandatory treble damages for all offenses could cause judges to adjust requirements that must be satisfied in order to prove violations, and even to alter substantive liability rules to make it more difficult for the plaintiff to establish the defendant's liability. So this is obviously not what the framers of the Sherman and Clayton Act had in mind. They weren't trying to make it more difficult for plaintiffs to prevail. We talked about all their rationales for treble damages. This is potentially an unforeseen consequence that over the years has developed. Professor Crane as well has noted that judges often act with extra caution in applying antitrust law, and describes the heavy artillery of treble damages as possibly one factor in that as well.
Okay, very interesting. So, following the logic of that argument, one might think in a but-for world without mandatory trebling, defendants come out ahead. But there could be a sense in which plaintiffs could benefit in such a world where findings of liability become less worrisome in terms of error costs.
That's certainly true, and that's one reason why we should be thinking really carefully about the positives and the negatives of treble damages and how they're structured, what type of conduct it applies to, before importing these from the Sherman and Clayton Act into new antitrust reform that's being debated in Congress and state legislatures as well.
So is there, is it time for a change? You mentioned new reforms that are perhaps in the pipeline. Has there been talk about eliminating treble damages? If not, should we be thinking about it, and what would alternatives look like?
Great question. And just before I get to that, just to lay the whole landscape out there, the two other rationales, criticisms of treble damages. One, Professor Garvey noted in his report that treble damages may, as a result of the uncertainty in the law and the magnitude of a potential damages award, they could deter socially beneficial conduct, and that's something we're always concerned about in this field: is how do we deter and prevent anti-competitive conduct without chilling pro-competitive activity. And the other is that these just might be draconian. In Midwest Paper Products, the Third Circuit noted that treble damages could even be a destructive force, and they cautioned against permitting these overkill recoveries whose punitive impact might be to cripple a defendant and overall lead to a deleterious effect on competition. So, to to your question, should we be thinking about alternatives? There's been some solutions proposed. An interesting thing is that, notwithstanding the Clayton Act and Sherman Act, not all antitrust violations do trigger treble damages today. You can take Section 5 of the FTC Act, which prohibits various forms of unfair and anti-competitive conduct, but does not provide for treble damages or a private right of action. A potential solution would be to tie the multiplier to the severity of conduct. So potentially treble damages available for per se violations that have no possible pro-competitive plausible rationale. But for rule of reason cases, for Section 2 cases, maybe we take a lower multiplier, maybe double damages or 1.5 or a sliding scale, depending on economic findings of how harmful is this type of conduct, and are there any pro-competitive benefits that we want to think twice before imposing this type of very, very onerous liability, the triple liability. So the severity of conduct is one dimension that could dictate the damages multiplier. The other is the detectability or concealability of conduct or illegal behavior. And the idea here is that some conduct is, it's right out on the open, some exclusive dealing arrangements, tying, predatory pricing. It's not that hard to observe the conduct. It might be hard to bring a case, but actually observing the conduct is not particularly difficult. Compare that to a very effectively functioning clandestine cartel, where we might never learn about this conduct. We might learn about one out of every two cartels, one out of three, one out of four. So having some way to enhance the damages multiplier based on how hard it is to detect the conduct and how likely it is that the conduct will go undetected.
Yeah, and all of those alternatives would, I think, to your paper's point, allow judges to make a judgment call as judges, about the risk of that type 1 error and sort of equal the scales between the two a bit more.
I think that's right. And whether it's Section 1, Section 2, criminal, civil, per se, rule of reason, it gives some flexibility to try to adjust the damages that we're talking about to the type of conduct that's at issue there.
And before we move on to sort of the last section of the podcast, there are a number of antitrust legislation making its way through Congress. Do they contemplate treble damages? Has there been discussion about that?
It's been a mixed bag, and for the most part, I haven't seen very much discussion at all. But the proposals are really run the full gamut. Some do tie damages to a percentage of domestic revenue. This is a little more like what we see in the UK and European Union. Other tech bills, Platform Competition Opportunity Act, open app markets in the House and then House and Senate respectively, do have some treble damages provisions in there. So it really is bill by bill, and what we're not seeing, or at least the public is not seeing, is a real meaningful engagement for, if we have treble damages in some of these reforms, what does that actually mean? What is that going to mean for both enforceability and actual substantive outcomes and case filings? There is the goal of these bills to deter or change some type of conduct? Is it to compensate victims? both? But we have to identify what our goal is here if we really are hoping to get it right.
To your knowledge, is that a new phenomenon, seeing bills in the past Congress that have, for instance, percent of revenue as a potential monetary remedy?
I'm not familiar with antitrust bills in that area. There might be in other areas of the law that would be interesting as well, and that should definitely be considered. Of course, it's not an outlier at all. It's kind of the norm in Europe, and a variation of that I know in some countries in Asia as well.
Well, I think you've certainly highlighted for us today the importance of thinking about this issue intently, and as we move forward, continuing to reassess the value of treble damages as, litigation and antitrust litigation evolves, and certainly in thinking about the evolution of antitrust law and new legislation, thinking again intently about whether we include treble damages and why we're including them. So Henry, really appreciate your insights and your expertise today. Before we let you go, we do ask all of our guests a couple of questions.
Okay.
So you have a really interesting sort of career path. You were at the government, you're now in private practice, and I think very importantly, you're now teaching. Tell us, I guess, do you have advice for young attorneys who are looking to do what you do?
Sure. I absolutely love the field, love my colleagues, people I've worked opposite. It's a great area of the law. It's a growing area as well. And to me, the most exciting thing about antitrust is it touches every element of the economy. It's all transactions, all markets. It's an opportunity to learn every day, both the law and the economy and the world we live in here. It's just such a broad field. There's so many different ways to be an antitrust lawyer. I started out doing mostly criminal cartel work at DOJ in San Francisco, then shifted to do more civil merger work, and now do really the whole gamut: conduct work, merger work, some as well in Section 1 cases. So it's an area where you can really grow into it and continue to learn all the time. And what I think is so special about this field is that that's the case for most people that are in it. Is we're people that like to learn, like to ask questions, like to really dig into a topic to understand it. So if you're someone that is sort of signed up for the lifelong process of learning and are comfortable with a field where the more you learn that you don't actually know, I think this is the perfect area for you.
And now for our final segment, the Curious Hat.
And now it's time for the Curious Hat.
Oh, I can tell they're going to put me in Slytherin.
Maybe we should make that the Curious Hat question. Which would you prefer, and which one do you think you'll actually get put in? No, but Henry, your favorite vacation spot and why?
Favorite vacation spot, I would have to say in Amagansett, New York, out on the toward the end of Long Island there. Just beautiful beaches, great bike riding. If you're there during the summer, really fresh produce as well. Haven't been there in a number of years. I'm now in Denver, Colorado. My family's all spread out, but we used to be New Yorkers once upon a time, and have really great memories there as well, doing all sorts of good summer beach relaxing time.
Was that like the summer vacation place?
For a number of years. For a while, we would just get in the car at an ungodly hour with a crazy number of sandwiches in the cooler and drive, several hours out there, set up shop until we just couldn't take the sun anymore, and then drive back to Westchester.
Pass out on the way home.
But eventually, my parents did have a place out there for a few years, which was excellent. I do miss it. It's a magical place.
It is indeed. Well, Henry, thank you again for your time today, and for all of our listeners, thank you for listening to this episode of Our Curious Amalgam.
Thank you for listening to this week's episode of Our Curious Amalgam. a competition, consumer protection, data protection, and privacy law podcast. It is produced and shared around the globe by ABA's Antitrust Law section. The opinions expressed by the participants in this podcast are their own and do not necessarily represent their employer or other organizations. If you like what you heard or would like to become a member of the American Bar Association, please check out what the Antitrust section has to offer at ambar.org/antitrust. You can learn more about our podcast at ourcuriousamalgam.com. If you have comments, suggestions, or podcast ideas, please reach out to us at podcast@ourcuriousamalgam.com. Until next time, thank you for listening.